so we'll get started on our webinar, U.S. Immigration Strategies for Biotechnology Companies. I am Miki Matrician, partner at WR Immigration. I'm here with my colleagues, Melissa Harms, who is a partner in San Francisco, and my senior associate attorney, Julie Galvin. Julie's based in Boston with me. So Melissa, Julie, and I represent a number of biotech companies of all sizes, from startups to publicly traded companies. And we're really excited to bring to you green card strategies specifically for the biotech industry. So a little bit about our firm. At WR Immigration, we specialize in employment-based green card matters. And we have 9 offices located across the US and 1 in Shanghai as well. Our proprietary technology, Rapid, is built on Salesforce, and we use that to combine it with high-touch services. We don't just process visas and green card cases. We work as an extension of HR and global mobility to streamline and strengthen your immigration programs. Our passion is really using technology and dynamic reports and predictive analytics to improve your and your employees' experience. If you aren't already using Rapid, please feel free to reach out to us and we would be happy to schedule a demo for you. It will be a game changer for you. So before we get started, just a little housekeeping here. Please note that anything we discuss during this webinar does not constitute legal advice. And if you have a question specific to your company or your employee situation, please reach out to one of our attorneys. We will accept questions in the Q&A chat. We'll try to answer questions throughout the Q&A feature if we can, but otherwise we'll reserve time at the end where we will address your questions. Here's a roadmap for our discussion. We'll first talk about PERM labor certification strategies. And then we'll talk about national interest waivers and how it can be a really great alternative option for biotech. Then we'll talk about the EB1 A and B categories, specifically addressing how to overcome some pitfalls or documentation issues common to biotech companies. And then with that, we're going to turn to industry benchmarking. Our technology platform is critical to gathering the data that is useful to our clients, and we're going to talk about how we use that and really drill down into the details on what our clients are sponsoring and not sponsoring. And then finally, we're going to talk about what to consider when building or updating your immigration policy. So first topic, Melissa, we're going to do PERM. Can you give us a quick overview?
Sure. So I'm sure everybody on this call is an expert in the PERM labor certification process if you've worked in immigration for any length of time. But the general building blocks for PERM is that this is a test of the U.S. Labor market to make sure that there are no minimally qualified U.S. workers to perform in the position. What does this mean? I'll give you a brief run through. We have to establish what the minimum requirements are for that position. We file something called a prevailing wage request with Department of Labor. I call that the black hole in the process because it takes a very long time for Department of Labor to tell us how they classify this position and what the wage requirements are. Once we receive that, then we do actually go out and recruit in the job. And this really is a good faith effort by the employer to show there's no minimally qualified U.S. workers. Some of the things we do to recruit are a little artificial, but they're required. For example, placing ads in newspapers. I'm pretty sure that most people don't do that these days as part of their normal recruitment, but we are required in PERM to do this. So what does this mean? Once we finish the process, then we can actually file that PERM labor certification. When I represent biotechs, we normally operate in a very tight job market. So proving shortage has not been a problem. In fact, I think a lot of my cases get 0 applicants by the time we're done with this. But it's still a hurdle that we do have to go through. Working with biotechs, I used our case management system, Rapid, that Miki referenced earlier, to run reports of some of the job titles that we've used for PERM in our biotech specifically. You normally think about in reference to a biotech, a scientist or a medical director, but we have a lot of out-of-the-box titles. These companies have very broad functions, just like any other company operating in the business world. So we have things like a manager of competitive intelligence, a manager of business operations, director of GXP compliance, GMP compliance, product managers of global commercial, supply chain planning. So these don't really fit in the normal biotech boxes. However, some of these occupations do need that scientific background to perform. For example, if you're manager of competitive intelligence, you need to know a little bit about the scientific world in which you operate. So this does require us to put our thinking caps on and blend those scientific requirements with a business or a real world application. It's hard for us to categorize these, but one of the occupations that we see a lot is the natural sciences manager, because it allows us to use that scientific background. The challenge with the biotechs and with the natural science manager in particular, the wages can be really high. So for example, in the San Francisco Bay Area, you can have a prevailing wage for a natural sciences manager that's as high as $260,000. So that would be your prevailing wage for that occupation, which a lot of companies obviously are not going to be paying to that level. This is where we bring in with my Biotech some private wage surveys. One of my favorites is the Radford Global Life Sciences Survey. I know Mercer and the Survey Group also have surveys they use as well. The disadvantage to that is that black hole I referenced with the wage, the prevailing wage request. When we use an alternative wage survey, it does take longer. So that black hole gets even deeper for some of those occupations. In terms of, what we see a lot of times with advanced degrees, a lot of biotechs will require a master's, and this is particularly true of the scientific positions, or a PhD with no experience. And that can be a little problematic because we do have to go out and, like I said, prove that there is a shortage. So what we do in those scenarios is we can require some specific skills these individuals gained as part of their education. And that's actually very typical with PhD positions. They're really looking at, for scientists, do they have any experience in a specific scientific principle that they need to use at that company. So we do use a lot of PhD plus 0, but you must have these special skills. When we do that, we have to be very careful that those are skills that they could gain as part of their education. So we can't require experience in a private company if we're saying there's 0 years of experience required. PERM might be the only option for a lot of entry-level people, and I know Julie will talk a little bit more about this coming up, but for positions where we have to show publications and a lot of experience or a lot of accomplishments, these individuals coming right out of school may not have that, so we may be looking at PERM for that.
Great. So Melissa, biotech really is a field where people are moving around a lot, are promoted really quickly, changes focus in their job. How do you handle that?
Yes, that's actually, my biotechs call me all the time with promotions, and it's very good to work at a biotech company because you are promoted very, very often, very frequently. One thing that we do is we try to generalize our job descriptions and our titles to allow for promotions. If there's not a material change where somebody goes from being an individual contributor to then managing and having a manager be the primary focus, 50% of their job duties as a manager, we'll try to keep the PERM labor certification going in reference to some of those, with some of those promotions and job advancements. We also look at, a lot of times biotechs will move people from one drug to another or one research platform to another. So we try to keep that very general. So when they do move, we haven't referenced that in the job description. So it does still apply when there is movement.
Great, thanks. Next, we're going to turn to national interest waivers. Melissa, can you talk about the current legal standard for national interest waivers? Yeah,
so this legal standard, it changed to me recently, but maybe not to many people recently. So we have a new case that we call the Dehanzar case, and this shows for this. First of all, I have to point out that this EB2 national interest waiver can be self-petitioned. So it's a little different than the PERM, which we just talked about, where you do need an employer to sponsor you. So the main legal requirements for this is that the proposed endeavor has both substantial merit and national importance. Secondly, that the foreign national is well positioned to advance the proposed endeavor. They do need an advanced degree as well. And then third, on balance, it would be beneficial to the U.S. to waive the requirements of a job offer and thus a labor certification.
Great. Now, earlier this year, the Biden administration issued new guidance, specifically targeting, STEM workers. Can you tell us how that initiative helps us in biotech?
Yes, in fact, our firm did a webinar back in February where I spoke on how this was going to change many different fields or many different immigration applications. And I would honestly say that the national interest waiver is probably the one where it had the most impact. What we saw after this initiative, we saw the adjudicator's field manual that USCIS uses to adjudicate these applications be changed and really reference some specific STEM initiatives. So for the first prong, for example, satisfying the substantial merit and national importance requirement. So in the STEM, the adjudicator's field manual now recognizes that many STEM fields will satisfy that requirement because they do have broad implications to demonstrate national importance. So once you've actually established that your field is that you're working in a STEM field, we can usually satisfy that first requirement pretty easily. The second prong, showing that the foreign national is well positioned to advance the field of interest, USCIS actually acknowledged that just having a PhD, even though any advanced degree is okay, a PhD will hold substantial weight in this category, and that's because they acknowledge that when you're doing work in a STEM field, you have to do a fair amount of specific research to get a PhD. So when you can show that your PhD is directly related to the work you're going to be doing that's of national importance, we can satisfy that. So that prong is going to be a lot less. It's going to be a lot lower standard than what Julie's going to talk about later with an outstanding researcher or an extraordinary ability petition. So that's some good news there on the second front. On the third prong, USCIS also recognizes the importance of progress in STEM fields that really shows it's important to U.S. competitiveness or national security. So this is where they really got into a lot of detail about how STEM fields can really satisfy this. So good news on the STEM initiative from the Biden administration, really helping our biotechs and helping STEM fields for this national interest waiver category.
Great. And I think, with the NIW is a great option now that premium processing is available for NIWs that were filed before February 1st of this year. So it's not caught up to all cases being eligible for premium processing, but definitely, in terms of preparing for a case where PERMs are taking so long now, it can take almost a year from case initiation to filing. To establish a priority date for somebody who is from a backlog country can be a really long time. And so I think biotech companies are looking at NIWs as an option to help more quickly establish that priority date.
And that's true. We're seeing, if you look at the prevailing wage processing times alone have stretched out to almost 9 months. And then recruitment has to happen for at least 60 days. So you add that together, you're easily at almost a year. So we are seeing this, and a lot of people are looking at premium processing being expanded for the EB2 category or for the national interest waiver category to where it will be something you can request in it at the outset. So we're actually looking at this more for our biotechs than we were in the past. One thing that we are also doing is we can have an employer sponsor these petitions, even though it is a self-petition, so we can kind of show the importance of the biotech work from the employer's perspective. So that's another strategy we're doing with these cases. Perfect.
Thanks. Now we are going to turn to EB1As. So Julie, would you like to give a broad brush overview before we delve into the questions?
Sure. So as Melissa said earlier, the EB1A is a very high standard. It's for aliens of extraordinary ability, is how it's written in the law and regulations. So what you need to show is that you have sustained national or international acclaim. And the fact that it's sustained acclaim is very important. It can be used for, it's a pretty broad category. It can be used for science, business, arts. Obviously, art is not as relevant here. But what we see in biotech cases are obviously the scientists, but also some of the more business-oriented roles that are a great fit for this category. Now, also, as Melissa said, this is not a category that somebody that might be in their a doctoral program or even a postdoctoral program, because you really do need to show a high caliber of achievements. You need to be able to show at least 3 of the criteria, and those include publications, having made original contributions of significance to the field, having press about you, having done peer review work, working in an organization with a critical reputation. There's a few others, but those are the criteria that we see most often. And not only do you need to just meet those 3 criteria, it's actually a 2-tiered analysis, so what we call the final merits determination. So USCIS looks at the criteria first and then says, well, in meeting those 3 criteria, does that really show that you have the sustained national or international acclaim? So it is a high standard, but there's also some very good benefits to it for people that do meet those qualifications. So we can skip that entire PERM process. So all of that test of the labor market, you get to bypass because your skills are so important and your achievements so extraordinary that we don't need to go through that labor market test. You can premium process these cases. So these cases do take some time to put together, so they can be somewhat time consuming on the front end to really put together a very strong case. But once we file, we can have a decision within 15 days if we don't get a request for evidence. The other 2 points that are very beneficial, there's no prevailing wage requirement. And generally speaking, across the board, even people from India and China, there's no backlog. So this can be a very fast-track way to obtain a green card if you meet the qualifications.
Great. So I think, in biotech, we often see, or we often do EB1A cases for a lot of researchers and scientists. Mm-hmm. And the regs don't specify a PhD as a requirement, but we do kind of look for that PhD degree. Can you file an EB1A for someone who has a master's degree and not a PhD, Julie?
So I've never actually done it for an EB1A, but it really is the totality of the circumstances, at least for a researcher. So I think if the norm is to have a PhD in your field, it may be more difficult with a master's degree. That said, if you were an author of a groundbreaking paper and have all of these other achievements that would meet the criteria, then it's possible, but I think it would be a more difficult case to make. Now, on the business end, say it's a more business-oriented role, I have been successful quite often with using an MBA. So I think it's very case and role specific.
Got it. For research roles, one issue that can come up is that at some companies, employees are discouraged from publishing articles. And if there's no more publications, how mm-hmm. would you get around that? Can you talk about some creative ways to show sustained acclaim?
Yes, absolutely. So publications are just one of the criteria that we have to meet. But again, there's 3 out of about 10, so you don't have to meet all of them. If publications are no longer something that you've done or haven't done a lot of, somebody that just moved into industry, we may still be able to rely on their publications. But if somebody's been working in industry for 5 to 10 years and they don't have those, we want to look at other options. One thing that I found very useful, one criteria, is the critical role in an organization with a distinguished reputation. I think it's quite often where we can show people have either studied at very elite institutions, that the companies that they have worked for have a distinguished reputation, and even the current employer that would either be petitioning, or again, these can be self-petitioned. If they have certain achievements in the field, patents, if there's press about the company, those are points we can certainly point to. We can also look at high compensation. For example, a startup, maybe there's not a lot of compensation in terms of salary, but what if there's a lot of stock options or equity that can be used to show in relation to other companies in the industry? So we do have to look at benchmarks for that. And for that, we tend to look at either the government data, very similar to what Melissa talked about for how we determine prevailing wages. We can look at the government data, we can look at private wage surveys, sometimes even salary.com and more anecdotal, but I really like the government's data because we're really, comparing their own data back to them and saying this is clearly 20% higher or much more than that. Another thing I've done before is looking at one of the criteria is memberships in groups that require outstanding achievements of their members. I've taken a very creative stance on this and looked at certain collaborations where you have to be very well renowned in your field in order to join this group. Sometimes they're more formal collaborations, when that's great, but we can point to anything. The great thing about these cases is you can get very creative. For somebody on in a more business-oriented role, so if you're not a researcher, which obviously we do see a lot of these cases, and we'll talk more about research with the EB1B, but if it's more of a business-oriented role, again, publications, peer review work, you may not see that. But we can also look at original contributions, and that might be something more along the lines of, if they're, let me back up and go through some titles we've seen before, and then we can kind of put that more into context. So, for example, regulatory affairs positions could potentially qualify. I've done one for VP of Business Development. For biotechs that are more VC-oriented and building portfolio companies, we can even look at, do it for an associate or a consultant or an analyst if we can show they've sourced really important deals, if they've generated a lot of funding, and if those companies have accelerated and contributed to achievements. We can all look at, how are those companies playing along in the industry to point to original contributions. So, if you've developed a key product and brought it into an international market, or somehow that product was used by other companies or really had a significance in the market, we can really look at that as well. So they said these are fun because we can get very creative, and someone might think that they're not extraordinary, but when we really delve into their career, they've made these achievements, even large growth within their department, we can point to as well.
Perfect. Thanks, Julie. So now we're going to turn to outstanding researchers. Julie, do you want to talk about that?
Sure. So this is a similar category to the EB1A. There are a few key differences. One is pretty evident from the name. This is only for research-oriented positions. It does require a job offer, so this does have to be petitioned by the company. Most biotech companies are great candidates for this. There is not a prevailing wage requirement, but we have to be able to show that the company does have the ability to pay a wage. It's a high standard, but not quite as high as the EB1A. The EB1B, you have to meet at least 2 out of 8 criteria. So you can't use the 2 criteria that are compensation, high compensation, and the original or outstanding contributions to an organization with a distinguished reputation. However, sometimes you can work those into the other fields, such as original contributions. So again, there's a lot of room for creativity there. You do need to show that the researcher has at least 3 years of experience. And the company itself has to have documented achievements to show that it qualifies in order to sponsor for the EB1B. So again, I think for most biotechs, you're going to have those those 3 full-time researchers, and you'll have maybe patents or awards or things that we can point to for achievements in the field. And USCIS generally takes a pretty liberal view as what achievements are. There's no real definition of that. So again, creativity is key here.
Right. I've come across this next question a few times in representing biotechs. Can you talk about how this category, how you would advise someone who asks, does the position have to be strictly research? have to be a full-time researcher just grinding out the research day in and day out? Or is there any wiggle room there?
That's a really great question. It has to be, I would say, a research-oriented position. Generally, we see your typical bench researchers, scientists, researchers, those general types of job titles. But if there is a research component, and we can say it's primarily a research component, for example, maybe it's a manager of a research study. So there's still guiding researchers, they're still having a lot of input into the study. Really, I think we could make, even though there's a management component, I think we can make a strong argument that that is still a research position. If it's more of an administrative position, like if you're taking research, but then going out into the field and trying to sell, like business development, even though there might be arguably a research component, I don't think that's going to be strong enough to qualify for an AB1B. So the more research oriented, and you can show that you're relying on research skills and that type of scientific knowledge, and at least doing I would say a majority of your time on those research type tasks, then you would qualify under EB1B.
Great. So one of the requirements that you touched upon earlier is 3 years of research experience. Does that really rule out all new grads, or is there some wiggle room there?
There is some wiggle room. So they want 3 years of research experience. Generally, we look at industry post-academic experience. It could be postdoctoral in some cases. But there are times when you can use academic experience, but that academic experience has to be considered to be outstanding in the industry, so recognized by your peers as outstanding. So perhaps you worked on a groundbreaking article, perhaps then in that case, or publication, or contributed to a patent while you were studying, potentially that would work. But ultimately, USCIS is going to look at the full picture and determine if that makes sense.
Great. Go ahead, Julie.
I was going to say, I know we're getting tight on time. One thing I wanted, so we can get to the benchmarking, but I also wanted to bring up startups, which is probably what you were going to ask, Miki.
You got it.
Yeah. So we do see, as Miki said at the outset, we do have work with a lot of larger companies, but we also work with a lot of smaller and very startup type companies. And because the EB1B does require that there is an ability to pay, that you have three full-time researchers and achievements, we need to make sure that startups would meet those criteria. Again, all of these are somewhat flexible with USCIS. They haven't really put out much guidance what documented achievements mean. But if you have the researchers, that's obviously more objective. We can look at, even what I've used before to show both ability to pay and documented achievements is if it's a brand new company, but it generated a large amount of funding, it got an initial investment, a Series A, something along those lines that's rather substantial, that can work to both show ability to pay and documented achievements.
Great, thank you. So we're going to focus now on benchmarking. And as I mentioned before, at WR, we leverage our innovative technology to compile and analyze all kinds of data, and industry benchmarking is one of those things in terms of sponsorship. And we really drill down into the details of what companies are covering in terms of cost and processes. So Melissa, can you talk about what you're seeing in terms of green card sponsorship?
Sure. And, like Miki said, I think this has been a common question among my clients for the 20 years I've been practicing. And when I first started, it was, well, about half, or, kind of trying to figure it out. But now that we have these sophisticated tools, we can really look at, we can drill down by industry and see what different employers are doing. And I think it is important to look at industries, because I do know, as I noted earlier in the presentation, that biotechs really do operate in a tight job market. So they really are looking at benchmarking across their competitors and what's industry standard to retain and attract foreign talent. So green card sponsorship, the timing is always, I think, probably the first question is, when should we start the green card process? And what we've seen recently as the job market has tightened is that time has shortened. So a lot of times, I think before we were seeing well over a year, but now what we're seeing is that roughly three quarters of our biotech employers will start within the 6 months, and within 1 year, and most of those are within 6 months. We do have a few that start very early on, and we do have a few outliers who wait past that 1 year. But that's the typical, what we're seeing right now is is I would say 3/4 within that first year. One of the other questions that came up, I mean, one thing you see in this presentation is that there's many different types of green cards available to your employee population. So do you sponsor for multiple green cards? Will you do a PERM and an EB-1B for an individual? And what we've seen is this is very few, and I'm going to say, pretty rare, that we'll see people do both, two multiple bases for green cards. We'll get into this a little bit later, but this is really critical that you have this in your policy. We'll talk about policies later on, because employees need to understand why, and they need to choose that basis very carefully.
Great. Thanks, Melissa. Julie, can you talk about the fees? What are you seeing with clients?
Sure. So on the green card end, I think it's important to note that for PERM cases, if there's no wiggle room there, the employer has to pay that. But for the I-140, it's in the 485s, the adjustment of status applications, we do see a variable there, but I would say most companies sponsor for I-140s. It's pretty universal that they will cover those. Most premium, those can be premium processed, and I'd say about half premium process those cases. If there is a legal need for them to do so, such as an H-1B employee that is running out of time and really needs that I-140 approval to extend their status, that's pretty universal that companies accept that they are, and are more than willing to pay that. And for the I-45 or the adjustment of status fees, I think probably about 3/4 do pay that. We see that pretty often, that the companies will cover that as well. When it comes to legal fees for dependents, we do see a variance there as well, but I would say about half of those will pay the green card costs for dependents as well.
Great. What about maintenance of underlying non-immigrant statuses? What did we find in our survey of our clients?
So we generally recommend, or pretty much always recommend, that non-immigrants do maintain their non-immigrant visa status while they're going through the green card process, where it's feasible and legally possible to do so. And I would say that our clients do tend to agree. It's very rare that they don't want to do that. And the reasons for that is, we've all seen the USCIS backlog, how long these are taking, delays, the chance of a denial. We don't want to put somebody, regardless of how slight that chance could be. If somebody loses their AOS, if it's not approved, then they don't have that non-immigrant status to fall back on. We're also seeing people needing to travel, and if their advanced parole is not approved or not ready yet, they'll have that non-immigrant visa that they can continue to use for traveling, as well as EAD processing delays. So there's so many, even on tight, strong green card cases, so many timing variables and processing delays that most companies do agree that it makes sense to keep their employees with that non-immigrant status so they continue to have that employment authorization.
Great. What about I-140 downgrades? Back in October 2020, a lot of people downgraded their I-140s. What did we find in our data?
I found that most of my companies were more than willing to do that if the employees wanted that. So I'd say about 3/4 of the companies did cover the second I-140 petition. It really seems like it's, the employers really want to make their employees feel supported from an immigration perspective.
Awesome. Melissa, can you talk about the two remaining less common bases for coverage?
Sure. So what we do see a lot of times, marriage-based green cards. So you have an employee that you're about to embark on a PERM. We're looking at long processing times for the PERMs, and then we've got to file the I-140 and the adjustment. And then they say to you, well, I'm marrying a U.S. citizen. Is that a way to get a green card? And we say, wow, that's a lot quicker. In San Francisco, it used to be about 4 months. It was really quick. That was the good old days. I'm probably dating myself. But now we're seeing those cases take about a year. But regardless, it is faster than pursuing the other routes and cheaper because it's a one-stop application process. So for that reason, I would say we looked at data. 2/3 of our biotechs will go ahead and pay for the marriage-based green card in lieu of the PERM. Now, this does get back to multiple basis. So we will usually give the choice to the employee. Would you prefer the PERM or the marriage-based green card? I have actually had people say, no, I want to do it through my employer. I don't want to rely on my spouse. I think that's perfectly fine too, but we do give that choice to the employee. One thing we're very careful about in these situations is communicating to the employee when our office represents them in the marriage-based case, that we represent their employee or their employer as well. So to be very careful with that dual representation situation. So if they come to you and say, as part of the green card application, I'm planning on quitting my job and joining my spouse, then we're obviously going to have a conflict there because we do represent the employer. So we're very careful about our communication and clearing all that with the employee so they're aware of that dual representation situation. In terms of naturalization, this is, once the employee has been a green card holder for anywhere from 3 to 5 years based on how they got their green card, they are eligible for US citizenship. It is rare that employers pay for this, but I am seeing some, particularly if it's required. Sometimes if you're on a government contract with sensitive information, US citizens have to be staffed on that project. So for that situation, then they would, employers will cover for that. Another situation I've seen, and I'm really involved in ESG with a lot of my global mobility people and how can we advance diversity, equity, inclusion. Other aspects might be the S of the ESG and the social, and looking at, well, if we sponsor or if we pay for these naturalization applications, more of our employees can vote. And voting is a civic responsibility and a privilege. So a lot of employers are saying this is a great way to increase voting among our employees. So then they might sponsor the naturalization in that scenario.
Great. Thanks for all those details. Yeah, and I think a lot of companies are thinking about immigration sponsorship as sort of part of the benefits package for talent acquisition and for retention. And because there's so many things to consider and so many processes that can cross over and can be, maybe duplicative in terms of green cards, it's really important for employers to be proactive in thinking about these in advance so that you can plan for it and communicate with your employees. And I think one thing I would like to add here is that, with the potential recession on the horizon, it's important to think about the ROI, right, on what you cover. Maybe right now you're covering premium processing on everything, but not covering your employees' dependent processes. Maybe it's time to kind of think about the possibility of shifting that. Maybe you cut the premium processing costs for the extensions and for the time being, and instead offer to cover dependent costs. And, you kind of think about what is the ROI that you want to maximize. So next we're going to turn to the immigration policy. What we found is that it's really rare to find companies with more than 100 foreign nationals that don't have a written policy on immigration sponsorship. But on the other hand, it's pretty common for startups and smaller entities to not have something formalized and written down. Maybe they have something informal, but a lot of smaller entities we found do not have a written policy. And, here's a plug for developing your policy is really that it's beneficial to, on so many fronts, one of which is that it cuts down on the questions that you'll receive on, do you cover this or do you cover that? Do you premium process this or that? It also, really importantly, limits legal liability and kind of takes the focus away from the nitty-gritty and really lets you focus on strategizing proactively on your program. Can you talk, Melissa, about what the building blocks are that are really must-haves for an immigration policy?
Sure, Miki. Yeah, and I want to echo your sentiments in terms of working with our startups. I have worked with some larger companies too who didn't have policies, but the startups, I also view it as a teaching tool. So a lot of startups will have somebody working on immigration or mobility who doesn't have a lot of background, and we'll sit down and go through, here are the things you need to think about. And in doing so, it allows them to kind of understand the whole life cycle of immigration sponsorship a little bit better, and then to align with executives at their company or people making the decisions on what are your values around employees and immigration sponsorship. One of the things we look at is eligibility, who is going to, or how are you going to make the determination of who you're going to sponsor, and coming up with those criteria. Exceptions are huge. So if you're going to have exceptions, you need to very clearly communicate in your policy that that global mobility or HR has the ultimate discretion in making those exceptions. We see exceptions for key employees, like, you have a critical employee who's basically the backbone behind your technology or your what your company is doing, you might make an exception and do 2 different routes for a green card for them, or an executive. If the CEO is a foreign national, you might be more willing to cover things for the CEO. So if you're going to have exceptions in your policy, make sure they're clearly outlined and that you're very clear that they are rare and that they're subject to the sole discretion of the policymaker. Cost sharing. So a lot of times people will say, well, I either cover all my dependents' costs or none. We'll say, no, you can actually cover, getting your dependent status, but you're not going to cover, for example, a work permit for a dependent. So you're going to make sure that your employee is authorized to be here and work. You're going to make sure their dependents can stay in the United States. It's very important. A happy employee is going to result in a more productive employee as well. So when their dependents are not covered and things fall through the cracks, we always say that that's going to result in, looking at your ROI, it's going to result in costs for you to make things right. But you can look at what is really critical in the cost sharing between different things. Repayment contracts, we get this a lot. People call them clawbacks. So let's say you want to sponsor a foreign national, but you're going to say if you leave within a year, you have to pay back this amount of fees that we spent on your green card. We can advise regarding the immigration regulations because there are specific fees that the employee cannot pay by law. So we will let you know what those are and help you carve those out. But we're really careful to make sure that our clients work with their employment counsel as well, because there are employment law considerations for those clawback provisions. And they vary by state, which can get very complicated for some of our large national employers because they might have a policy in California that doesn't work, but it works in Nevada. So we're very careful to make sure that they really evaluate those clawbacks. And the last thing that I really advocate is communication with stakeholders. So once you develop this policy, making sure that it's in your handbook, it's on your intranet if you have one. You might do a town hall if it's new and announce the policy to your foreign national population. That's something we've done as the Employment Council, so we can come in and explain why a policy makes sense and be the backbone behind it as well. But also your recruiters and your managers too. So you want to make sure that your talent acquisition team isn't making any promises that are inconsistent with the policy you've developed.
Thank you so much, Melissa. Yeah, and for those companies who haven't had the opportunity to sit down with your immigration counsel and develop a new immigration policy, or maybe you haven't looked at your policy in a while, our WR attorneys would be happy to meet with you, and we can walk through what makes sense for specifically your program. And we really would discourage using a template, right? Because there's no one size fits all policy. It really is dependent on what your company culture is, what your company's executives are expecting, what the budget is, and all of that. So, and you want to be able to look at each provision and justify to your senior leadership why you are recommending certain costs versus other things. And to Melissa's point, I think it's really important to communicate all of the details and the implications and go over the policy with not just your foreign nationals, but all of your stakeholders. Part of it is, there's a saying about contentment and happiness is based on, whether there's a gap between expectation and reality, right? So setting the expectation right at the outset, I think, is so important regarding what you're going to cover for your foreign nationals, what you're not, and the timing of processes being started. So I have one question here. I know we are running out of time, and we try to stay to as close to about 30, 40 minutes as possible. We're a little bit over, but I have one question here. Do you have any advice for HR who is faced with an employee asking us to do an EB-1B after the PERM has been approved? What are the things that you need to consider?
That comes into the multiple bases of green cards, and this is where you should have this outlined very clearly in your policy. Is if you proceeded on the PERM basis, and then you want to move to the EB-1B, we only sponsor for one category. And one way that we really address this head on is when we look at people for PERM, we might say, wow, this person's kind of close to qualifying for EB-1B, and we'll give the employee the option and say, would you like us to start with a PERM right away, or would you like to wait a year and see if your citation record goes up? And I know we talked about a lot of private companies don't allow publications, but they might have a publication from right before they join the company that's going to increase in citation count and make their application stronger. Or we might tell them you can do things like peer reviews, and that's allowed by your company, and do other things to bolster your application the next year. So would you rather wait a year if your immigration status allows it, or would you rather just go ahead with PERM? So really being proactive when we start our green card process and make sure we involve the employee to the extent that it makes sense, so we avoid these situations down the road.
Great. Thank you so much to both of you, Julie, Melissa, and thank you everybody for joining today. If there are any questions that we didn't get to, please feel free to reach out to us and we can email you, correspond with you by email. Thank you so much for joining us today. Have a great day.